Hi everyone, welcome to today's webinar. I'm Dan Xiang, the moderator of this webinar. As you may know, CNIPA issued the new guidelines for examination of Chinese patent law last year, which had come into force at January 20th of this year. This webinar will walk you through some important amendments and focus on chemical cases for us to better understand them. The topic of this webinar is amendments to CNIPA guidelines for examination, explication and case study, chemistry related. Now, please allow me to introduce the speaker, Mr. Xin Xu. He is an experienced patent attorney and also qualified as patent civil litigation attorney and patent administrative litigation attorney, recommended by All China Patent Attorneys Association. Mr. Xu obtained his bachelor's degree and master's degree in environmental science and technology from Shanghai Jiao Tong University in 2009 and 2012. The patent applications handled by him mainly involve glass, polymers, novel materials, and organic electroluminescent materials. Now, let's invite Mr. Xu to give his presentation. If you have any questions, you may raise them online, and after the presentation, Mr. Xu will give his answer.
Hello, everyone. I'm very glad to have an opportunity to host today's webinar discussing recent amendments to the guidelines for examination of the Chinese patent law, especially for the chemical technical field. I am the speaker, Xin Xu, from Chemical, Pharmaceutical, and Biological Department of Shanghai Patent and Trademark Law Office. And Dan Xiang is today's moderator. He is the Deputy Manager of Chemical, Pharmaceutical, and Biological Department of SPTL. Today, I will start from 4 aspects, introducing the amendments. The first and second portions are the amendments related to patentability, that is, the novelty and inventive step. Next, the third portion is the amendments involving the criteria for whether claims can be supported by the description. At last, the fourth part is the amendments associated with supplementary data. Besides, I will also refer to some specific cases which may help us better understand the impact of the amendments to our patent application work. At last, we may discuss anything desired. First part is an important amendment to the guideline which involves the no loss of novelty. Previously, a patent application would not lose novelty if any of the following 3 situations occurred within 6 months before the date of filing, or the priority date if applicable. The first situation is when it is first time disclosed at an international exhibition organized or recognized by the Chinese government. The second situation is the first time disclosure at an academic or technical conference. And the third is disclosed by a third part without the applicant's consent. Currently, a new situation is added. That is, if the technical solution of the patent application is disclosed due to a national emergency or extraordinary situation, such a disclosure will not destroy the novelty. In addition, with regard to the previously existed third situation, before this amendment, the academic and technical conferences are limited to only those organized by the departments of the State Council or national academic groups. However, after the amendment, it now can cover those organized by international organizations acknowledged by the relevant departments of the State Council. After that, we will go to part 2. The second portion is the amendments related to inventive step. When determining whether a patent application involves an inventive step or not, CNIPA follows the 3 steps approach, which includes the first step is to find the closest prior art. The second step is determining the distinguishing technical features and the technical problem actually solved thereby. At last, we shall make a judgment whether there exists a motivation in the prior art. For the first step containing the 3-step approach, it should find the closest prior art. The previous guideline merely stipulates that the one either belongs to the same or different technical field is qualified. And among the 2 kinds of prior arts, the one in the same or similar technical field should be considered at first. There comes a question. During the examination procedure, although most of the office actions include 1 or more reference documents, sometimes the first office action issued by the examiner may not include any reference documents. Stated differently, the examiner does not designate the closest prior art. It thus comes to the question whether the closest prior art necessarily exists or should be designated. Before we attempt to answer this question, we may refer to the amendments in section 3.2.1.1, chapter 4, part 2 of the guidelines for examination, which now further emphasizes that the prior art related to the technical problem to be solved by the patent invention should be given a priority. That is, CNIPA recognizes that the importance of the same or similar technical problem. In the past, the applicant was often confused by a totally irrelevant reference document cited by the examiner as the closest prior art. In the applicant's opinion, one with ordinary skill in the art generally would not start from such the totally irrelevant reference document for modifications and obtaining the claimed technical solution of the patent application. However, even if we argue from this aspect, the examiner tends to respond by asserting that as long as the reference document discloses the most technical features of the patent invention, it is qualified as the closest prior art. Now, let's come back to the previous asked question. In my opinion, currently, although CNIPA still does not give an express answer to the question, the signal showing the importance of the same or similar technical problem may be our arguable point. After the first step, the second step in the 3 steps approach is the determining of the distinguishing technical features and the technical problem actually solved thereby. The amendments to the guideline in this section adds a very important explanation on the technical problem actually solved. In particular, it stipulates that the redetermined technical problem should not be identified as the distinguishing technical feature itself, nor should it contain guidance or implication for the distinguishing technical feature. by not be identified as the distinguishing technical feature itself, nor should it contain guidance or implication for the distinguishing technical feature. What does that mean? Let's come to some specific cases for the answer. The first case, let's see, case 1 relates to a ceramic honeycomb body comprising a plurality of intersection walls having a microstructure. Among others, the claimed technical solution defines that the microstructure comprises a bimodal pore size distribution, in which an intrabead media pore size is less than an interbead media pore size, and the body comprises a trimodal pore size distribution, comprising a first peak corresponding to some particular features, a second peak corresponding to other particular features, and a third peak which corresponds to yet other particular features. The examiner in charge of this patent application acknowledges that the closest prior art at least fails to disclose or suggest the bimodal pore size distribution or the trimodal pore size distribution. However, the examiner asserts that the technical problem actually to be solved is to provide the two particular pore size distributions. It can be seen that the so-called two particular pore size distributions just belong to the situation in which the technical problem to be solved is identified as the distinguishing technical feature itself, which is now expressly forbidden by the guidelines. We thus could argue correspondingly against the examiner's rejection on this issue. Especially, we can start from the technical problem actually solved. For this patent application, it is allowed upon our response to the first office action without substantially amendment. After case 1, let's go to case 2, which seeks for the protection of a UV curable resin composition comprising two components. Component A is an organoploid hexagon, and component B is a photoinitiator. The claim limits that a mole ratio between the thiol groups and acne groups in the component A is greater than or equal to 1. The examiner recognizes that the closest prior art is silent on the particular ratio as claimed. But she concludes that the technical problem to be solved is how to improve the solubility by modifying the ratio. We can see that with the expression of by modifying the ratio, the technical problem contains the implication for the distinguishing technical feature, which is not allowed by the amendment to the guidelines. Besides, as we can see, the truth is, it is the patent application which first discovers the relationship between the ratio and the solubility. By concluding the technical problem solved as how to improve the solubility by modifying the ratio as asserted by the examiner, she ignores the creative activity of such a discovery, and thus it belongs to the situation of the technical problem containing guidance and implication for the distinguishing technical feature, which is not allowed by the guideline. After we discussing the first two steps, let's go to the third step. The third step is that when determining whether or not the claimed invention is obvious to a person skilled in the art, the examiner should make a judgment starting from the closest prior art and the technical problem actually solved as to whether or not the claimed invention is obvious to a person skilled in the art. In the course of the judgment, what is to be determined is whether or not there exists a technical motivation in the prior art, as to apply set distinguishing technical feature to the closest prior art to solve the existing technical problem. That is, the technical problem actually solved by the patent application. Where such a motivation would make one with ordinary skill in the art, when confronted with the technical problem, to improve the closest prior art and thus reach the claimed invention. Please be advised that although the amendments to the section 3.2.1.1, chapter 4, part 2 of the guidelines for examination does not include content related to this third step of the three steps approach, we believe that the following cases may give us some helpful and useful guidance when responding to the patentability rejection. First, let's go to the third case. Case 3 relates to a glass ceramic composition. The technical solution of independent claim 1 requires the inclusion of colorants in the glass precursor for forming the glass ceramic composition. Has to be mentioned, an important information is that the closest prior art generally does not include the colorants in the glass ceramic, as the colorants may adversely impact the glass ceramic. Reference document 1 cited by the examiner also states that the colorants are not preferred. The examiner attempts to combine reference document 2, which discloses a glass composition comprising colorants, with reference document 1, so as to destroy the inventiveness of the patent application. However, the examiner does not consider the following facts. The first is that reference document 1 at least suggests the exclusion of colorants, if not deemed as expressly excluded. And 2 is that due to the substantially different compositions between reference documents 1 and 2, one with ordinary skill in the art generally would not anticipate the success of the combination of the two reference documents. During the work, we argued from the above 2 points, and this patent application is allowed. In addition to the above specific cases faced during our work, we may also refer to Chapter 10, Part 2 of the Guidelines of Examination. This section is several provisions on the examination of invention patent application in the chemistry field. The amendments to Section 6.1 thereof provide a plurality of new cases and explanations thereof. Hereafter, I will refer to 2 cases included therein to show criteria on the notable progress held by CNIPA. Let's see case 4. Case 4 relates to 2 compounds in which the patent invention's compound comprises oxygen atom, whereas the prior art disclosed amine group at the same position. The only difference between compounds IVB and IVA is the replacement of amine group with oxygen atom. Although oxygen atom and amine group both belong to typical electrical isotopes, the cancer cell growth inhibitory of compound IVB is about 40 times higher than that of IVA. With the help of the particularly value of 40 times higher cancer cell growth inhibitory, the claimed compound is deemed as inventive by CNIPA, though oxygen atom and amine group both belong to typical electrical isotopes. After that, let's go to see case 5. Case 5 similarly relates to 2 compounds having the same situation. As can be seen, the patent invention's compound comprises oxygen atom, whereas the prior art discloses sulfur atom. The differences between lies in the different connection atom, in which compound Vb is sulfur, whereas compound Va is oxygen. When the pattern application fails to show a detailed improvement or comparison between the two atoms, it cannot be deemed as involving an inventive step because the two atoms belong to the same group and have the similar properties said by CNIPA in this section. After discussing the amendments related to patentability issue, let's come to the amendments related to support by the description. Article 26, Item 4 of the Chinese patent law stipulates that the claims shall be supported by the description and should define the patent protection sought for in a clean and concise manner. And Section 3.2.1, Chapter 2, Part 2 of the Guidelines for Examination further explains this article, which states that for a claim generalized by a generic concept, it should be examined whether such a generalization can be supported by the description. If the generalization of the claim includes the content speculated by the applicant, and its effectiveness is difficult to determine and evaluate, the generalization should be deemed as cannot be supported by the description. If one with ordinary skill in the art has sufficient reasons to doubt that the generalization of the claim covers technical solutions which cannot solve the technical problem aimed to be solved by the application, the generalization should be deemed as cannot be supported by the description. As can be seen from the two versions, the amendments lie in that the old version uses the expression of has reasons to doubt, whereas the new version requires sufficient reasons, which means that the criteria on the reason for doubt is raised. However, the applicant may still wonder what is the difference between reasons and sufficient reasons in our practical work. Let's come to see the amendments to the case given in this section. As can be seen from the two versions, the modification lies in that the old version does not explain why one with ordinary skill in the art would doubt the technical effect. In contrast, the new version explains that the reason is because the physiological characteristics which vary greatly between planet seeds. Therefore, from the difference above, at least according to our prosecution experience, it should now be the examiner's burden to explain why the technical solutions covered by the generalization of the claim cannot be conceivable by one with ordinary skill in the art, rather than the applicant's burden to prove that the generalization and the corresponding technical effect can be reasonably anticipated. Part 4 will discuss the amendments related to supplementary data. In the past, generally speaking, supplementary data is acceptable only when it is used to support the advantageous technical effect involving impatibility rejection. As can be seen, old version of Section 3.5, Chapter 10, Part 2 of the Guidelines for Examination expressly stipulates that the supplementary data cannot be used to overcome the insufficient disclosure issue. The reason is because CNIPA holds an opinion that the supplementary data are provided after the filing date, which disobeys the intention of the protection from disclosure. However, currently, CNIPA allows the applicant to submit the supplementary data to overcome the insufficient disclosure rejection, provided that the technical effect demonstrated thereby can be conceivable by one with ordinary skill in the art from the original application documents. With regard to this issue, according to our prosecution experience, the criteria on the technical effect conceivable by one with ordinary skill in the art is still very strict. For example, if the description merely describes that a component can improve performance of a compound, when an improved solubility of the composition resulted therefrom may face a risk that it would not be accepted, and the examiner may deem that the improved solubility cannot be ambiguously determined by one with ordinary skill in the art, based on the original disclosure of the improved performance. Therefore, when drafting the specification, a clear technical effect should be disclosed. And only under such a circumstance, the supplementary data which demonstrates the technical effect will be accepted. After discussing these major amendments to the guidelines for examination, we can come to some takeaways concluded therefrom. For the new version of guidelines for examination, it may comprise the following 5 important amendments. The first is 2 situations are added for no loss of novelty. One is first disclosure due to national emergency or extraordinary situation. And another is the academic and technical conferences organized by international organizations recognized by the relevant departments of the State Council. The second important amendment is that the technical problem in the 3 steps approach of inventive step is now much emphasized in both designating the closest prior art and not allowed to conclude as the distinguishing technical feature itself, nor should it contain guidance or implication for the distinguishing technical feature. The third important amendment is that the particularly data for demonstrating an advantageous technical effect is very important. In addition, the fourth point is that it is now the examiner's burden to explain the support by description rejection. At last, the applicant is now allowed to provide supplementary data to overcome insufficient disclosure rejection, though the criteria are still very strict. Thank you for coming to today's webinar.
Thanks, Mr. Xu, for his wonderful presentation. Now let me check the questions. The first question is about no loss of novelty. The question is, first-time disclosure as an international exhibition organized or recognized by the Chinese government will not destroy the novelty of the application. We notice that USPTO complies similarly to stipulations on this issue. Is there any difference between USPTO and the CNIPA?
Well, it is a very good question. Generally speaking, the no loss of novelty allowed by CNIPA seems that it is stricter than USPTO. For example, as discussed above, the first-time disclosure should be within 6 months prior to the application, which is required by CNIPA. However, at least according to my knowledge, that USPTO allows up to 1 year. Furthermore, we know that CNIPA only allows 4 situations. 3 previously existed and one newly added. That is, first is the first-time disclosure due to national emergency or extraordinary situation, which is added in this amendment. The other 3 are first-time disclosure at an international exhibition organized or recognized by the Chinese government, and first-time disclosure at academic or technical conferences. And the last is disclosed by a third part without the applicant's consent. It can be seen that only for these 4 situations, the patent application will not lose its novelty. However, USPTO seems that does not limit the form of the disclosure. The above 2 points seems to be the major differences between the criteria held by CNIPA and USPTO. Thank you for the question.
Okay. The second question is about submitting supplementary data. The new version of the guidelines for examination will be ineffective from January the 20th of this year. The question is, if the application was filed before this date and was rejected for insufficient disclosure, is it allowed to submit such data to overcome the deficiency?
I understand. First, I have to say that since the new guidelines has just come into force at January 20th this year, I haven't faced the above situation in my work. However, I can say is that in the examination practice here, CNIPA holds the principle that it should favor the applicant. That is to say, the supplementary data, if it's submitted to overcome the insufficient disclosure issue, it should be accepted. It should be accepted, though the application might be filed before the date into force. Thank you.
Let me see. Oh, it just seems there are no further questions. Okay. If no further questions raised today, today's webinar will be finished. Of course, you may email to us if you have any further questions later, and we will give you prompt reply. Okay, thanks again for Mr. Xu's wonderful presentation, and also thanks for your listening. See you next time and have a good day.
Have a good day.